For the record, Your Honor, Elliot Allen on behalf of
Counsel, we can't hear you. We can't hear you.
You can't hear me?
Counsel, your appearance, please.
Can you hear me now? Can you hear me now, Judge?
The fuck are you saying to me?
I can hear you a little bit, but this isn't working for me. This isn't working for me.
I don't know what's going on here.
I don't either, but again, I don't either, but it's not working for me. Can you put your appearance on the record, please?
Yes, Elliot Allen on behalf of John Powell.
Okay, whatever two devices that you're on, can they be right together so that when you're looking at the camera, you're looking at me as opposed to me looking at the side of your face?
Is that better?
What did I just say?
Is that better?
It's a little better. All right, Mr. Powell, your name, please. Unmute yourself, sir.
John Lamont Powell.
Thank you. Today is a date set for a final pretrial conference. How are we proceeding?
Your Honor, we have been really slow at trying to get work out with this.
We can't hear you. We can't hear you.
Could you hold on for a second? Let me see if I can get this done.
I'm going to recall the case. Mr. Powell, I'll put you back in the waiting room. Let your lawyer try to get his devices together.
Okay,
Thank you.
2 very boring minutes later.
Be scheduled for jury trial.
Today is the date set for final pretrial conference. The court is going to continue a not guilty plea on behalf of Ms. Broden and set the matter for jury trial. I believe August the 26th. At 9:10. The complaining witness has appeared today, and therefore, sir, you are not required to appear on July the 10th. On July the 2nd.
Meanwhile.
Mr. Allen, let's try again. Are you? Oh, well, when did I start recording on the thing? Mr. Allen, can you adjust the camera so that we're not looking completely down your throat?
I think I'm losing my mind. How long have we been here?
I feel that I'm going to adjourn the case and we're going to come back in person. I don't know. I don't know. Right? I don't know.
Yeah, they're telling me it's taking 2.5 weeks to repair the screen, so we may have to come back in person.
No, now we are going to come back in person. So let's come back next week.
Yes, ma'am.
Help me understand, counsel, why you would get up and walk away from court in the middle of me talking. In the middle
to get the calendar today.
Okay, so in the future, next time you're supposed to say, Your Honor, give me a minute. Your Honor, may I step away for a second?
I'm sorry.
What's the best day for you to come in next week? Not other than Wednesday. I have a heavy docket Wednesday.
Next week is good.
Counsel, you have to talk directly into your device. We cannot
Well,
hear you.
Next week isn't good for me. I have a medical procedure.
I can't hear you.
Next week isn't any good for me because I have medical procedures that are scheduled for Monday through Friday.
You got a medical procedure every day next week?
Yes.
Yeah. Okay.
All right, we're coming Monday, February 5th.
I thank you, Your Honor. I appreciate it.
No problem. Nine o'clock in person. Have a great day. Stay safe.
Thank you. You too.
Judge, the only thing is that paragraph 2 goes on to state that there's it looks like, no, it's a different charge, isn't it? In 2010, you must have been convicted of more than one robbery.
It appears they were on the same
So
day.
one was used, one of those robbery convictions was used in the elements of the unlawfully possessing of a firearm by a previous convicted felon. Paragraph.
Oh, okay, I get what you're saying.
Then the other robbery conviction is used in paragraph 2 to enhance the punishment up to a second degree felon punishment.
This is something wrong, same day, but just. Yes, sir.
Marcus? Marcus, here's this affidavit for indigency that was not signed. Are you indigent?
Yes, sir.
That means you don't have enough money to hire a lawyer.
Yes, sir.
Is that right?
Yes, sir.
Your monthly income now is zero?
Yes, sir.
This wasn't filled out by the magistrate. It should have been. Expenses. Well, you don't have, you have expenses. You can't pay a dime of them, I guess. Do you swear that the statements you're making to me are true and correct, so help you God?
Yes, sir.
Are you married or single?
Single, sir.
You have any dependent children?
Yes, sir. Correct.
Okay. Give me just first name and age.
Gabrielle Hamilton, she's 16 years old.
AMBRIA.
AMDRIEL.
EL. And how old?
And she's 16.
16?
Yes, sir. Yes, sir.
You got a 16-year-old. And who's next?
And Cassius Yada Olives.
Cassius.
Yes, sir.
How age?
He is 4 right now.
Sir?
He is 4. And I have Legend Hamilton. It's LEJIN and Hamilton, and he has just turned 3.
16, 4, and 3.
Yes, sir.
You know, I'm looking at you like,
I
you know, this look I have of you
I
got responsibilities more than just you. You've got children who depend upon you, and there you sit in the jail, charged with let's see, what is this?
Felon possession.
Felon in possession of a firearm after being convicted of 2 robberies. And
Even if I explain it, it doesn't make it right because it happened and I was actually trying to go and move to another city. And that's the reason, that's why I had everything in the car.
I see here's the probable cause affidavit here, and were you the only one in the car?
Yeah, actually, I had a friend that I was taking to get something to eat. We had actually went to eat. That's why I stopped in Beaumont. I was headed to Baton Rouge. We went to get something to eat, and I was taking him because he didn't have a car, so I was taking him to get him something extra. So when I left, he would have something to eat, and that's when I got pulled over with this.
You said there's another case pending?
Yes, sir. There's one more coming. It's supposed to
Let
be
me say,
presented
yes,
grand jury.
drugs.
Yes, sir.
Police smelled marijuana. The odor of marijuana, which has a distinct smell. And they found a baggie of assorted tablets, and they believe it to be, apparently they must have done some kind of a field test, and it was methamphetamine. Once again, you got the kids at home and you're flirting with danger. All right, Mr. Grove can help you navigate through this. What do you want to do today?
Judge, I'd like to wait till we get to the new case. And I would point out to the court that smell of marijuana was unburned marijuana. So I'm somewhat skeptical with the officer being able to smell that outside the car, but that's a trial issue.
This 2023 conviction for possession of marijuana won't help him much.
So how about the methamphetamine tablets? What do you have to say about that?
Well, Judge, I'm not saying
Okay.
that I know about that except
All right.
from the
Okay.
original report.
All right. But the point is that here you are, and
Yes, sir.
the children are. I can't imagine that. You got to fix this mess. And what's the most important thing you can give to your children?
Me being there.
Anybody. What's the most important thing?
Well,
Within that, I would say a good example, because kids emulate their role models, which are naturally their parents. Are you a good role model? Not standing there in the red jumpsuit.
but they don't even know that like I would smoke marijuana because I would never smoke it in front of them or nothing like that.
Sir, you've got you've got 2 convictions of robberies, and now you've got a new charge of a weapon that you made statements to that I can read them, and they're indicative of you accepting responsibility for it. But the problem is, and then this methamphetamine stuff, once again, that's not good example setting for children. Okay.
And I will do better given the time after this is all over with.
All right. So we will reset how long, David? On
Just a couple of weeks. I think I can get discovered.
Okay.
Probably.
Reset.
Then
Then Mr. Hamilton for 2 weeks. Thank you. Okay. DeAndre LaFleur. DeAndre LaFleur.
That's that will be, please, Your Honor.
Yeah, are they ready?
Yes, sir.
Great. LaFleur, please, Tommy.
I don't believe that Mr. Floor has been sworn in, but
I'll need to.
but
Your Honor, I've discovered something in this case regarding restitution amounts.
restitution was never.
Too late now, sir. You can't bring it up at this stage.
Okay.
I'm just testing you. So what were you gonna say? She's here now. We want her to hear what you're going to say. Yes, sir.
Restitution was never assessed in this case.
Why not, do you think? Well, what are we doing? Are we putting her on probation?
Well, it's up to the court. We have a cap of 4 years.
Okay, a cap
on the probation case, and then a cap of 1 year on the state jail.
Well, we're going to need a pre-sentence report, right? Right. If it's a cap, I always order a pre-sentence report. And then that restitution issue needs to be inherently part of that.
Yes, sir.
Okay. Yeah, a cap. I'm just generally, I want to hear, a report about her history and all, and that's the only way I can make an informed decision. Sometimes on motions to revoke, a lot of times we don't need. I can use an old report and then probation office can update. But here on these, I always like a pre-sentence report. If that's what we're going to do.
How much was the restitution that you found?
So there is restitution on the MTRP in the amount of $3,700 and in the PSI report as well.
And then the 0904
Okay. She's on probation.
forgery.
Oh,
Yes, sir.
oh,
One case is,
Oh,
the older case is that, and then 2 new offenses from
well,
this year.
let me look at this because
This is working, swear fingerprint real quick. While you're looking at that.
Pre-sentence report, so I don't know about that. Oh, no, I'm not doubting it. I just had to see it.
Then there's some other documentation in the file of an itemized report from damages from the original case, from the victim, and the two amounts don't match up.
That's one of the pre-sentence reports, so you have to put up about a month. Yeah, it's good. It's all right. Okay. This can't be today.
what are you doing? You should have been weeping and crying before you made this bad choice of going into the bank while on probation to defraud. Gosh, don't cry now. That's not going to help you. It won't make a difference. You know better. You weren't on probation a year, were you? No. I'm reading this. Hold on. Okay. This looks like she attempted to get some money. Did she actually get money?
I don't believe
No,
so.
I think they stopped it in when it was happening.
I think the new case, he did not actually get any money. I think you're talking about the original Parker case, Judge.
No, I'm looking at this probable cause affidavit from January 31st of this year that caused her the motion to revoke probation. And it says she was in the bank, and I think forged something for $500, and they stopped it. They caught on that was not.
And she was arrested. Yes, sir. I believe there's no restitution on that new case.
Okay.
But there was on the burglary case, which occurred prior to her being put on probation in February, I believe, 2022.
Okay, that was what she was on probation for. What's that? Yes, sir.
Yes, sir. The restitution at the time she was placed on probation was listed on the order as to be determined. There was some communication that went on, and I'm not too sure of official amount was ever established. I have documentation from the victim and an itemized receipt that lists one amount at $5,320.99. And the amount that's on the MTRP
It's
and
37.
the PSI is $3,700.
I haven't reviewed the pre-sentence report from the prior case.
How long has she been in jail now? From this time? From February? I'm sorry.
From July.
From January?
July.
Oh, okay.
But there came of the restitution came out of this paragraph with
Okay.
the amount of the loss. I do not have anything that I see from the victim.
She was booked into our jail July the 7th.
Why was that? Why? Because I signed this thing was filed in March. Why did it take 4 months for her to get arrested? Did she abscond?
Yes, sir.
Oh, okay. See, we can figure it out in less than 5 questions. Okay.
When she was arrested initially for the
And
2 new charges, she was let out on.
okay, we haven't amended that motion yet to include the absconding where she. So let me get this straight. So she's arrested, bonds out, and never reports again. And then how were you arrested?
I was arrested in my home. This time I was arrested in
All right. So what is our plan that y'all think is the way to do this?
We have a cap, the offer is a cap of 4 years TDC on the motion to revoke probation for burglary of habitation to run concurrently with the check cashing case. That would have been the one in January of 2023. She also was charged with a possession of a forged identity, and that case is being dismissed. So out of the 2 new cases,
I only have 3.
Yes.
Oh, I see. Okay.
3 cases.
All right. We're going to take just a short break here.
A little longer than a few minutes later.
And 9:06 to be dismissed,
Yes, sir.
but you hadn't done that yet, right?
That's it.
I'll put it aside.
Until the plea was done.
And Mr. LaFleur, that's you? Come on up. 2 cases, 21-36635 and 23 CR 904. Now there's another one, 906. That case is going to be dismissed. But in these 2 cases, there's a motion to revoke unadjudicated probation and a new state jail felony of forgery. And do you understand what is here today?
Yes, sir.
What we're doing? You are here with Mr. Grove, your attorney, and the state's attorney. And does the defendant, Mr. Grove, waive a formal reading of this motion to revoke unadjudicated probation in 36635 and in this new indictment in 904? Can we proceed so?
Yes, Your Honor. However, from discussions with Mr. Laird, I believe that our plea agreement is somewhat different than what is reflected on the plea papers.
Okay, well, we can change those, right?
And it might be best to enter that. I believe that the court will entertain revocation on the burglary of habitation case, which is
36635.
Yes, sir. And then for a final conviction of 10 years probation for 10 years is what we were talking about. And then on the case, the forgery of financial instrument, which 904. Is 0904, would be 2 years probated for 5 years. And restitution, I'm sorry, on the first case, because there was over $3,000 worth of restitution owed on that.
Okay. Does the defendant waive formal readings of these pleadings? Can we proceed in such?
Yes, Your Honor.
In summary, on the motion to revoke unadjudicated probation, 21-36635, ma'am. And raise your right hand. Do you solemnly swear or affirm all the statements you're going to be giving during these proceedings are true and correct? So help you God.
Yes, sir.
Lower your hand. In summary, this motion alleges that on February 22nd of last year, you were placed on 10 years deferred or unadjudicated probation for burglary of a habitation. Is that true?
Yes, sir.
Allegation 1 alleges that on or about January 31st, 2023 in Jefferson County, Texas, you committed the offense of forgery. And that is represented in this new indictment 904. You understand what you're charged with here?
Yes, sir.
Is that true and correct?
Yes, sir.
Are you pleading true and correct to this allegation 1 in this motion to revoke probation voluntarily, knowingly, intelligently, and because it is true? Yes. You understand by voluntary, knowing, and intelligent plea of true, that is enough to grant this motion to revoke probation. Your probation can be revoked. You can now be found guilty and sentenced to the full range of punishment of no less than 2 nor more than 20 years confinement in prison. Knowing that, you insist on pleading true today?
Yes, sir.
And you're pleading true voluntarily. You understand and appreciate the consequences of pleading true. Agreements have been reached here where you would be confined in prison for 10 years, placed on regular probation for up to 10 years. 23 CR 906 would be dismissed, and this probation will run concurrently with 0904. The new forgery case. Is that your understanding of the plan?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
We're going to go to 904. Hold 36635 in abeyance. In 23 CR 904, this indictment alleges in summary that on or about January 31st, 2023 in Jefferson County, Texas, you committed the state jail felony of forgery. You understand what you're charged with here?
Yes, sir.
If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. Additionally, you may be assessed a fine not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty and sentenced to 2 years in the state jail. That would be suspended and you would be placed on probation for up to 5 years to run concurrently with 36635. Is that your understanding?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this indictment charging you with the state jail felony of forgery, ma'am? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, knowingly, intelligently, and because you are guilty of what the charging instruments allege?
Yes, sir.
Each of these cases, I'm showing you what's marked as State's Exhibit 1. Did you sign those documents
Yes, sir.
and understand them and discuss them with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence in each of these cases
No objection.
without objection admitted. These state that you are mentally competent to enter your pleas, which are freely and voluntarily made in each case. You know what you've been charged with. The indictments have been read to you. The motion to revoke probation has been read to you. And you are guilty of the indictment in the state jail felony and pleading true to allegation 1 in the motion to revoke probation, which is represented in the new indictment of forgery in 904. You were giving up your rights to a jury trial, the right to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Is that so?
Yes, sir.
Pre-sentence reports waived?
Yes, sir.
All right. I'm going to follow these agreements. If nothing further, I'm going
Judge, I would ask the court to hear a small bit of testimony from the defendant, Ms. LaFleur, concerning what the court often does, providing upfront jail time on felony probations.
Yeah. Okay.
And I don't know if this is the appropriate time.
As good as any.
Good.
If I follow these agreements that I intend to do, one of the conditions of probation is that I can sentence you up to 180 days, 6 months in the county jail as a condition of probation. Do you understand?
Yes, sir.
How much time did we figure she had?
I think that'll figure it out for time, Judge.
How much time have you already served? And
I've been there since July 7th.
July
That's
7th?
right. She's booked in July.
All right. Yeah. And this, you have unfortunately a rich history of some wrongdoing here. And you commit this new crime of forgery, which is a crime of deceit, after the burglary of a habitation, which is a serious crime of invading someone's dwelling home without their permission and authority, and the states you with intent to commit assault entered a habitation. And so do you understand this court can sentence you up to 6 months in the county jail as a condition of probation in each of these cases to run concurrently? Do you understand?
Yes, sir.
All right. What are you asking for, Mr. Grove, on that?
Judge, I would ask for as small upfront time as possible. And let me go ahead and just give you the arguments now.
Yeah.
Miss LaFleur has graduated from Memorial High School in Port Arthur, graduated in 2016. She is the oldest of 5 children. She and all the children lived with their mother. Her mother got sick and started having problems about the time or before the time that she was placed on probation on the burglary case, which would have been February of last year. And basically her mother went down, and her mother passed away shortly after the arrest in the check case at the credit union. She died on March the 1st, 2023. And again, Mrs. LaFleur is the oldest of 5 children, one of which is a 16-year-old son, who is the youngest one. And currently, he doesn't have a place to live. And taking care of that. She also has 2 twin sisters that are 18 years old who have graduated from Memorial High School in Port Arthur. They are starting school this week in Austin, Texas, going to a college. And that same thing.
What college?
Sir?
What college?
Austin of I can't get the name, but it's downtown. I haven't.
It's what?
It's downtown in Austin. I haven't.
Austin Community College?
It's a community college, yes, sir.
There's ACC.
She also has those children to take care of. The other 2 are older than 18.
You have a lot of responsibilities, it sounds like.
Yes, sir.
Which begs the question, why are you here when you have all those responsibilities at home?
I wasn't.
People rely on you.
They do.
And they're not getting a lot of help from you when you're in the jail clothes at the jail. And you're the oldest. I'm the oldest in my family. And you're supposed to be a role model. You're supposed to set an example, a good example, you're going to set an example. one way or the other. You can be good or bad. You can't blame the siblings who go, I wanted to be just like her. You got to do well. So they can say, I really want to be like her because she's a great person and makes good choices.
Judge, before you hand those off, the state is requesting, as in the pre-sentence report, the $3,700 restitution.
Yes.
On the.
We've agreed on that one. The parties have agreed. And Ms. LaFleur, you've agreed that the restitution owed in this burglary of a habitation case, which was to be determined at the sentencing. And we said that was to be determined. And for whatever happened, I think it was because you kind of slipped off the edge here and we kind of lost track and couldn't get a determination. But the state is stating $3,700.
Yes, sir.
Is going to be owed for the damages in that burglary of a habitation. And is there any objection from the defense on that? Are y'all waiving any other rights? Of challenging that determination.
We waive any other rights. I
Okay.
don't believe we would have any
Right.
because it is a new probation
What is
case.
this? Let me ask, what's the state's feeling about upfront time?
Judge, you heard I was offering a cap and was going to argue for penitentiary time. So I really don't know that she's learning her lesson. She keeps committing crimes while she's on probation.
Don't do
What, ma'am, what'd you say?
I said I could do better.
Okay, well, I don't think any of us doubt that, but you've got to do it, not us. We can only give you opportunities. You've got to make the best use of those chances.
But in order to pay restitution, she's got to get a
It's
job.
probation, so
Yes, sir. I don't have a problem if you don't want to give her upfront jail time and
she's gonna get some.
okay. Then
How much is she getting credit for right now on this? You're talking about the burglary.
If I can look at the burglary. What she did before. $49 days. On the burglary.
All right. So if nothing further, again, on 21-36635 again, your deferred or unadjudicated probation is revoked upon the court now finding you violated your terms of probation in this motion to revoke unadjudicated probation filed on March 21st of this year, and finding that you have pleaded true knowingly and voluntarily to the allegation one for committing forgery on or about January 31st of this year in Jefferson County, Texas. Again, your deferred or unadjudicated probation is revoked, and you again earlier, based upon your pleas of true voluntarily, knowingly, intelligently, and State's Exhibit 1, which was admitted that supported your guilty plea, I now find you guilty beyond a reasonable doubt of the underlying burglary of a habitation that you were originally placed on probation for on February 22nd, 2022. You are hereby found guilty beyond a reasonable doubt now of that and sentenced to 10 years in prison, probated for 10 years, suspended for 10 years, regular probation. you must pay, you must pay restitution in the amount of $3,700. And also you, how much did you say you had credit?
It's 49 days.
Yes. And you will, you will serve 41 additional days in jail, which will be 90 days, 3 months. That will go toward your upfront time. I could still sentence you to 90 more as a condition of probation, but that will be the term. That will be a term of probation in 36635, and in 904 you have pleaded guilty voluntarily. This state jail felony, you were mentally competent to do so. You understand the consequences of pleading guilty. With sufficient evidence supporting your guilty plea from State's Exhibit 1. Admitted to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony of forgery. You are hereby sentenced to confinement in the state jail for 2 years. That is suspended. You are placed on regular probation for 5 years. There is no fine on this one, I don't believe.
No, sir.
But you have a lot to lose by failing on probation. You understand you're kind of running out of chances now. All right, do well. You have responsibilities to yourself and others. Honor those. That is all.
Thank you.
And there is a motion to dismiss.
Anything further?
No, thank you, Judge.
Nothing on behalf of Mr. Pitts. Thank you, Your Honor.
Mr. Pitts, in the future, you have to face the sun. You have to face the window. Otherwise, I can't see you. And so you got to face the window if you're going to come on Zoom the next time. All right. We're all set. Have a great day. Stay safe.
Okay, there's literally nowhere else. The TV and stuff.
Okay,
right here.
then come in person. That's all I could tell you. I'm not going to hold court in the dark with you anymore.
Didn't know coming in person was an option.
Oh, fuck.
It's always an option. The court is open.
Not when we started this case. The 6
Okay,
years
but
old.
we're not when we started, sir. And I don't understand why in the world this is any type of back and forth. I simply said you have to face the sun or come in person. Now that you know that coming in person is an option, just choose. But I'm not going to go back and forth with you. Have a great day and stay safe.
Thank you. Court now stands in recess.
You have just seen a trial in General District Court, and you know how it ended.